The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Thank you for joining us for the Rights of and Resources for the Most Vulnerable Populations. I see that we still have a few people that are joining us, but we have a full webinar today, so I'm just going to get started and they can join us in a bit. So, because this is a webinar, you all are all muted. If you can type in any questions that you have in the questions box, we will be sure to get to them. Usually we save our questions for the end, but we would like this webinar to be as interactive as possible. So feel free to input your questions during, and I will ask your questions throughout the webinar. Also, this webinar is being recorded, so the webinar recording and slides will be available on our webinar library, and you can find that at www.cceh.org, and you can go to our webinar library. And I'm sorry, I did not do this at the beginning. I am Amber Freeman, the Training and Technical Assistance Coordinator with CCEH. So for today, I have some great people joining me from the Connecticut Alliance to End Sexual Violence and the Victims' Rights Center of Connecticut, and they're going to give us a wonderful presentation on seeking justice and supporting recovery, how lawyers help crime victims seek justice and repair shattered lives. This is something that I think is very necessary to have right now. We are seeing an increase in crimes, and there are many victims that are coming forward, and it's really important for us to be able to provide some type of assistance and provide some type of support and resources for them. So I'm very happy to have this webinar today. So for this webinar, we have Maura Crossan, who is the Program Director and Senior Attorney, and we also have Kaylee Rector, who is the Assistant Program Director and Associate Attorney. So thank you both for being here today, and I'm going to let you all have it. So thank you.
Thank you so much, Amber. It's such a pleasure to be here and give this presentation. Just as a caveat, we have not ever done this presentation virtually, so please bear with us in just working that the different dynamics. But as Amber mentioned, if there are questions throughout that you would like to be addressed rather than waiting till the end, please feel free to throw those in the chat box, and we're happy to be interrupted and take those questions while the topic is current. So with that, I will begin. I'm Maura Crossan. I'm Program Director and Senior Attorney. I am coming up on my 5-year anniversary with the Victim Rights Center. I've been a practicing attorney since 2013. Prior to law school, I was a family violence victim advocate in the court, and I worked for domestic abuse services in Greenwich. So I have been working with victims of crime probably now for about 15 years. So it is near and dear to my heart, and really, such a niche area that I'm really grateful to have found early on in my career and continued as an attorney. With that, I will be also introducing Kaylee Rector and just asking her to give a little background as well.
Thanks so much, Maura, and it's a pleasure to be here with everybody today virtually, and I look forward to the opportunity to hopefully being able to connect in person someday in the near future. As Maura said, I am Kaylee Rector, and I am the Assistant Program Director and an Associate Attorney at the Victim Rights Center of Connecticut. I have not had such a long tenure as Maura. I did just join the team earlier in March, right before everybody went into lockdown, so it's been an interesting year. But although I am new to VRCCT and exclusively victim rights practice, I have been working with vulnerable populations and survivors for my entire career. I started practicing in 2014. I was working in the Bronx doing child welfare and abuse and neglect actions in family court. After that, I worked with domestic violence survivors before coming back to Connecticut, where I was doing humanitarian immigration law at the International Institute of Connecticut for about 2.5 years before joining VRCCT. So throughout my career, I've been working with DV survivors, sexual assault survivors, child victims of abuse, and foreign-born and domestic-born survivors of a variety of types of violence, including persecution and torture. At VRCCT, I'm exclusively practicing immigration law. I will hopefully be receiving my admittance to the Connecticut bar in the near future and will be able to expand my practice. But for the time being, I'm working exclusively with humanitarian immigration cases, so assisting undocumented survivors of sexual violence and other types of crimes in stabilizing their immigration status.
Thank you so much, Kaylee. So our agenda for this webinar, we're going to get into the program, specifically what Victim Rights Center does, how we think we can help, how we have historically helped, and how we think lawyers can help crime victims. I'm going to be sharing with you case examples throughout, and then we'll at the end pause for any questions. But as I mentioned, if questions come up, don't hesitate to put those in the chat box, and Amber will alert us to any questions as they come up. For those of you who are not familiar with the Victim Rights Center, the Victim Rights Center was founded in 2013. It is the only program in Connecticut exclusively serving the legal needs of victims of violent crime. We were a standalone nonprofit from 2013 to 2018 when we were acquired by the Connecticut Alliance to End Sexual Violence. Currently, we have a staff of 6 associate attorneys, 2 of which are bilingual. We have 1 bilingual case manager and paralegal. Currently, we have 2 certified legal interns. And just so you have an idea of where our undergraduate and law students join us from, there's many different universities and colleges throughout both the state and country that we have had hosted. So if you are a student or know any students who are interested, we are always willing to talk to students about potential internship opportunities. Our current catchment area, while we wish we were statewide, and certainly our short and long-term goals would be to expand our services statewide, we currently are offering services in New Haven County, Middlesex County, Hartford County, Talon County, Windham County, and parts of Fairfield County. I will say that because of COVID and being remote and offering remote services, not having to travel to courts, not having to travel to offices, having most of our meetings with clients and service providers virtually, we have been able to serve clients in other areas that are outside of specifically these areas. And Kaylee, do you also want to mention for immigration what that catchment area is for you?
Absolutely. So we're able to be a little bit more flexible with the catchment area for exclusively immigration cases because if they are in the court process, there's just 1 court in Connecticut and that's located in Hartford, but most of our clients are not in the immigration court process. And so there's no traveling to court involved, which allows us to be a little bit more flexible. And especially now that we're working remotely, as Maura said, just provide those services remotely. So for clients who are seeking immigration legal services, as long as they live within Connecticut, we would be able to serve them regardless of specifically where in the state they are.
And when we were originally founded, we were founded by 1 attorney back in 2013, and we've obviously grown not only in numbers as far as staffing, but we've expanded our catchment area further and further. So I'm confident that we will be statewide sometime in the near future.
So a little more specifically about what we do and what services we offer. Our practice focuses really specifically on providing trauma-informed and holistic legal representation. And this means that myself, Maura, and all of our staff, and attorneys and non-attorneys, are trained in trauma-informed practices and how we can incorporate those into our legal relationship with clients, understanding that so many, if not all of the clients that we're working with are trauma survivors, and that trauma carries with them in every part of their lives, including with their interactions with the legal system. So that's a really integral part to how we approach our roles as advocates and attorneys. We also try to be as holistic as possible. We know that our clients come often with a variety of complex needs, and in order to try to avoid them having to go to 5 different people to get 5 different types of legal representation, as much as possible, we do try to serve as many of those needs in-house as we can. We focus specifically on serving victims of sexual assault and sexual violence, but we are also able to serve victims of other specific crime types and victimizations, which are listed here. We are including with some of the materials that we can send to Amber, our referral form, which does lay out our catchment area and the specific victimizations that are covered by our funding. So you don't always have to come back to refer to the slide. But if anybody does have questions, if you've got a client and you're not sure whether they would fit within the victimizations that we cover, always please feel free to reach out to us, and we'd be happy to work that through with you. And one other important thing to note, as is written here on the slide, is that we do not charge for our services. Our program is completely funded, and that means that our clients never have to pay for our legal representation. So I mentioned that we try to be as holistic as possible. So we provide representation in a variety of practice areas listed here, and we're going to dive into a couple of those in more detail that we think might be most relevant to the populations that you all are working with. But I would say the bulk of our work, and please feel free to jump in, but I'd say the bulk of our work is probably in pre and post arrest advocacy. So working with crime victims, asserting their rights throughout the criminal process, both before and after arrest and post conviction if applicable. But we also handle protective orders, Title IX matters, housing on a limited basis, immigration, as I mentioned before, and also some limited employment matters. So we often get the question of, why do victims need an attorney? And especially in the criminal context, because a lot of people will think, okay, well, the prosecutor is going to be there and represent the victim. And although the prosecutor may, to some extent, be representing, what the prosecutor's aims are may line up with the victim's wants, that's not always the case. And ultimately, at the end of the day, the prosecutor does not actually represent the victim. The victim is not the client of the prosecutor. The prosecutor represents the state and the interests of the state, which again, may be in line with what the victim wants, but may not be. So especially in the criminal context, it's important to delineate those roles and see why having a lawyer specifically for the victim can be really valuable. But one of the big reasons that we advocate victims to have representation, both in the criminal process and in other matters, is, as we said, many of them have been through trauma, whether exclusively through the victimization that led to them getting involved with us, or if they've had multiple traumas throughout their lives. But that trauma will impact them in many different ways, including how they're going to be interacting with the legal justice system and with the legal process. So to have an attorney who can provide legal advice, with whom they have protected attorney-client privilege for their communications, who can explain all of their options and help them navigate those complex processes, all while having an understanding of their trauma, can be really helpful and supportive and healing ultimately. And there's also, depending on the case type or the legal need of the client, there may be a possibility that theoretically the client could proceed pro se, meaning that they would represent themselves. That's something that we'll sometimes see in protective order cases, where folks will file the paperwork themselves and go in to talk to the judge on their own behalf. And while that is an option, and the legal process does allow for it, that can be incredibly overwhelming and re-traumatizing for somebody who has been through so much already. So again, having an advocate, an attorney who is exclusively there to represent that client's interests and that client's rights can be a really helpful piece of their healing.
Yeah, so we just have one question. I know you're going to go into more detail, but there is a few questions actually about the kind of education assistance that you offer.
We'll get to that.
Okay, so that is included.
Thank you.
Thank you.
So this is where we'll specifically talk about how we as lawyers can assist victims in the different areas that Kaylee mentioned. We, again, tried to tailor it towards what we thought would be most relevant to you all. We almost didn't even actually put in a section about education or Title IX. We weren't sure if it was too far afield from the work that the attendees were doing, but I'm glad that that question was asked and that we kept it in. So specifically as far as criminal law, pre and post arrest advocacy, what that means and what that looks like in practice. So we can assist victims with filing reports, with actually even prior to filing reports, we can assist victims with deciding whether or not they want to file a report. You know, immersing yourself in the criminal justice system can carry with it a lot of both legal consequences, but also emotional consequences. And so we're able to advise and assess whether or not filing a report is even what the client ultimately wants to do. So after that decision has been made, we can support them in filing the report, attending interviews at the police department, following up with law enforcement officers, and tracking warrants, all of which can be very overwhelming for a client, all of which can take a long period of time from when a report is filed to when a warrant is signed, can sometimes be even 6 months, a year. So having someone who's able to stay in touch with the police officers or detective bureau, also stay in touch with the state's attorney's office if appropriate, can be really helpful so that the victim can go on with living their lives and not worried about all of these follow-up phone calls. If an arrest is made, we're able to file an appearance on behalf of the victim to provide notice to the court and the parties of the case that the victim is represented. And then we can keep the victim informed and engaged in the case throughout its lengthy pendencies. I've had cases that have gone on for 2 years, 3 years. I've even had a case that went on for 6 years once. Now with the pandemic, things have, there's been such a delay in the criminal justice system. So we're going to be seeing those delays for a long time. So ensuring the victim is still supported and engaged in the process is going to and will now more than ever be very important. We can ensure that a victim's privacy rights are not violated. We can file motions if we need to protect those rights, as far as, especially medical records, mental health records, things that are routinely subpoenaed into court without necessarily a victim's knowledge. We can, make sure that all the proper procedures are followed. We can provide legal advice to assist the victim in making decisions about the case. I think that is a big difference between victim advocates and what we do, because we can actually provide that legal advice, while as victim advocates can provide information and support, they can't legally advise clients or victims. We can advise prosecutors about what victims' wishes are for the case. We can help prepare for disposition conferences, sentencings, and/or trial. Really importantly, we can act as a buffer between the defense attorney and the victim. In Connecticut, under the rules of professional conduct, once someone is represented by an attorney, no other attorney can speak to the person without going through the attorney. So the buffer role is really, really crucial here. We can facilitate meetings with state's attorneys. State's attorneys often have heavy dockets and high caseloads, so we're able to set up those meetings to have one-on-one sit-downs with the prosecutors, while victims may not have, without us, have been able to set those up or have not known that they can set those up. And it can be really helpful in a case. We can also be appointed to act as a guardian ad litem in a criminal case. Many people know of GALs in the family court context, but GALs are also can be very important in the criminal court cases. So we get appointed to represent the minor child, to act as to let the court know essentially what is in the best interest of the minor victim in a criminal context. So just to illustrate a few case examples, and I'll probably think of more as we continue the conversation, but I think some of the most important success stories that we've had in this field specifically in pre and post arrest advocacy, in working with clients who were unsure whether or not they wanted to report, through counsel and support of our office, we're able to successfully go to the police, give a statement. We were able to track the warrant. We were able to make sure that the police officer involved was following proper procedure and was also doing all of these steps in a timely manner. We actually were able to have the detective walk a warrant through in a stalking case where the behavior was escalating to the point where we knew that the only way to stop the offender was to have him be arrested. And so we were able to expedite that process to ensure that that happened. We've supported several clients successfully through full criminal trials to help them in not only getting ready to testify, but in sitting in the trial and observing it all and reporting back to victims. And supporting them through that process, and then obviously through the verdict and victim impact statements. I think those are probably the best examples I can think of at this point in time. So we can move on. So specifically, in education law, we handle Title IX cases. So under Title IX of the Education Amendments of 1972, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So this does not apply to private schools or activities. This is specifically applies to any program or activity receiving federal financial assistance, which is important to understand. Title IX is a civil right that prohibits sex discrimination in education. It applies to all students regardless of gender identity, and it applies to all schools who receive federal funding, so both K through 12 and high school, in addition to higher education. Most people think of this in a college context, but also K through 12 and high school, Title IX applies to. So Title IX requires that schools disseminate a notice of non-discrimination, that they have a Title IX coordinator. It requires the school to adopt and publish a grievance procedure outlining the complaint, investigation, and disciplinary process for addressing sex discrimination, harassment, and violence occurring within the program. Schools are required to be prompt when receiving a complaint and in how they adjudicate or remedy the hostile educational environment created by such behaviors. I did put a resource for anyone that may not be aware of knowyour9.org if they want to delve into more information about Title IX. I know that recently Title IX this year has gotten a lot of attention because new rules went into effect in August of 2020, which deeply affect Title IX and how it is being now applied in school context. So that's a great resource for more information on that. Similarly to pre and post arrest advocacy, what we can do in Title IX cases is also, counseling a student on whether or not they want to make a report to the Title IX coordinator if violence or harassment or discrimination is happening. And then if they decide to report that behavior, we can support the victim through that process of reporting, of communicating with the Title IX office, working on no contact orders and safety plans. We can help them with any of the investigation and support them through any follow-up interviews, deciding what evidence they want to submit to a fact finder, if an investigation is underway. And then ultimately, after the investigation is done, if there is a hearing, we can support the victim through that adjudication process, whatever it looks like for the specific school. That is the bread and butter of what we do as far as education. There have been other cases where we have had to get involved, specifically with the school when the victim has been, when the student has been a victim, and there are areas of their education that are being affected because of the victimization. So many of our students have PTSD and need some accommodations in school. Some of them have even more severe mental health issues due to the victimization. We are able to work with schools and with counselors. We have attended PPTs in order to help with accommodations for the students. So we are also willing to go into the schools and assist victims with those rights directly if needed.
So another area that we mentioned before that we help with are getting protective or restraining orders. And there's a few different types in Connecticut, so it's helpful to differentiate between them and understand how they may interplay with one another. So first off, there is a protective order that can be issued in a criminal court by the judge in criminal court in connection with a criminal proceeding. Those are often issued simultaneously, automatically by the judge in that case. And they can be, they obviously do provide a level of protection and can be very helpful, but there may be circumstances in which there is not a criminal protective order, or maybe there hasn't been an arrest yet, or maybe the protective order in criminal court only covers the victim and doesn't cover their family. So in certain circumstances, if there is a qualifying relationship between the applicant for the temporary restraining order and the person they're seeking protection from, that victim may be able to go into family court and get a temporary restraining order, or a TRO, in addition to, or if there isn't one, in place of a criminal protective order. So the TRO is issued by a judge in family court, and as I mentioned, it can include other people beyond just the victim. So if they have children that are living with them, they might be able to have the children included there. And it may last longer, because the criminal protective order, if there is one, would usually last throughout the duration of the case. So it's possible that the victim may want protection beyond what the criminal protective order would be able to provide. I mentioned that for a TRO, there does need to be a qualifying relationship between the applicant and the person from whom they're seeking protection. So those relationships would include spouses and ex-spouses, parent, child, or other relative, somebody that the victim lives with currently or has lived with in the past, somebody that the victim has a child with, even if they've never lived together or been married, and also somebody that the victim is currently or was formerly dating. There are certain circumstances in which, if the victim is a minor, they may have to testify at a hearing at the judge's discretion in order to get this TRO, but that may or may not always be the case. And again, that can be an area where it can be really helpful to have an attorney representing the victim, to be able to advocate for why that is or is not appropriate in that particular situation. It is also possible within the context of family court for somebody applying for a TRO to also get an emergency ex parte custody order. Ex parte means that it is an application made directly to the judge without the other party, in this case, the person that you're seeking protection from, being present. Because it's an ex parte application, there does have to be a very high level of urgency for that to happen. There has to be a pretty significant risk of danger, because obviously due process would normally require that the other party be present to have notice. But if that level of danger is present and there is sufficient proof to meet that threshold, then a judge may issue a temporary emergency custody order that there may be that the parties would have to come back at a later date so that both sides could be heard, but at least on a temporary basis to meet that high level of urgency, there can be that order issued in conjunction with a TRO. So that's in family court for victims who have one of those qualifying relationships that I mentioned with the person that they're seeking protection from. However, there is also another option if there is not such a relationship between the victim and the offender. In civil court, there is also a protective order that can be issued. And again, this is different from protective orders that are issued in criminal court. In civil court, there is no familial relationship, no qualifying relationship that is necessary. However, there does need to be sexual assault, sexual abuse, or stalking. So there's some limitation on what type of victimization or harm has occurred or is feared. One important thing to note is that there is some significant, or there can be significant interplay if there is a criminal case pending, if somebody is also seeking to apply for one of these types of orders. And again, that can be an area where we as attorneys for the victim can play a role in helping parse out, what are the pros and cons, if you have a criminal case pending and if you want to apply for a civil protective order as well, what are the risks in doing that, because sometimes those statements could then be brought up in the criminal case and used against the victim. So these are all considerations, like Maura said, that we are able to advise the victims about legally and help them make the best decision for them in that moment. So another case type that we help with is humanitarian immigration relief, and this is currently my bread and butter. And there are a large number of immigration case types and ways that people can obtain immigration status. But when we refer to humanitarian immigration relief, it's usually referring to a limited number of case types that are based in some way on some type of victimization. That victimization can sometimes be domestic, meaning that the harm occurred here in the United States, or it can be based on a harm that occurred or that the person thinks will occur if they have to go back to their home country. So I've outlined 5 of the most common that we see and also 5 that we handle at VRCCT. Try to list them maybe in order of the most likely, the likelihood that you'll interact with any of them. So we'll start with the U visa, and that is for victims of certain serious crimes, including sexual violence like rape and sexual assault, who have been helpful to law enforcement, meaning that they had information about the crime that occurred, and they were helpful to law enforcement by giving them that information. It's not enough for the victim to just say that they were helpful. They actually have to get a certification, and there's a special form for it that has to be requested. But they have to actually get certification from law enforcement. That can be police, both local or federal, the judge, the prosecutor, anybody in the law enforcement or the context of the criminal case can certify that. But you do have to get that certification signed, confirming by law enforcement that the victim was helpful in the case. The U visa is a really great option because there's a lot of flexibility for folks who may have entered the country unlawfully or have other immigration violations in their history, and sometimes even criminal histories as well. One downside to the U visa is that there is a very long wait list. So there's only a limited number, 10,000 per fiscal year, that are available, and we've reached that cap every single year for the past 6-7 years or so. So currently the wait to get a U visa is somewhere in the 5 to 7 year range. So it is not an easy or short process, but it can be a really good option for folks who have been victimized and who may not be eligible for other types of relief that require that aren't as flexible in terms of any past violations of immigration or criminal law. Related to the U visa is the T visa, which is similar in many ways, but narrowed a little bit more specifically. So the T visa is available only for victims of severe human trafficking in persons, and that can be either labor trafficking or sex trafficking. So again, we're dealing with victims of crimes, but specifically one type of crime. With the T visa, there is a requirement that the victim has to cooperate with reasonable requests from law enforcement. But the difference is that you don't need that certification of helpfulness. So typically providing some sort of notice to law enforcement, maybe a phone call or a fax or a meeting with your local prosecutor or FBI, will be sufficient. And then if they have any requests from there, an additional interview, or if the case goes forward with the prosecution, complying with any reasonable requests in connection with that, the victim will still have to comply with those requests in order to maintain their eligibility for the T visa. But that requirement about the helpfulness certification isn't quite so strict. Now, it's important to note that if you look up the list of crimes that make somebody eligible for a U visa, trafficking is listed on there. So you might ask, what's the difference? Why might somebody apply for one but not the other? Every situation is going to be unique. And again, that's going to be where an attorney can come in handy and be able to weigh the pros and cons. But generally speaking, the T visa carries some significant benefits over the U visa, namely that recipients of T visas are eligible for refugee benefits. Those are federal benefits that include cash assistance, employment assistance, and those are typically only available for refugees and asylees. So T visa recipients are the only other category of folks who can tap into those benefits, which are immensely helpful as victims are starting to rebuild. Another benefit is the wait time. So T visas do have a cap as well, and ironically, even though the cap is lower, so 5,000 per fiscal year as compared to the 10,000 for U visas, we've never actually hit the cap for the T visa. So instead of a 5 to 7 year wait with the T visa, you're looking at maybe a 2-year wait, possibly a little less depending on the circumstances. So that does move a lot faster than the U visa. So wherever somebody might be eligible for both, there can definitely be a benefit to proceeding with the T instead of the U. Another type of immigration relief that's based on victimization is relief through VAWA, the Violence Against Women Act, which, among many other wonderful things, carved out this pathway for victims of battery or extreme cruelty who were married to U.S. citizens or legal permanent residents, are children of U.S. citizens or legal permanent residents, or are parents of adult U.S. citizens. Excuse me. The individual would need to show through both their own written testimony and other types of evidence that they were subject to abuse by the U.S. citizen or permanent resident that they're related to. They also need to show other requirements, things like good moral character. So generally that means no or very little history of criminal or immigration violations. But that basically the relief through VAWA can basically allow them to get a green card on their own to petition for themselves without the knowledge of the abusive U.S. citizen or legal permanent resident. So it essentially cuts the abuser out of the immigration process, and this form of relief was created with Congress recognizing that oftentimes immigration status is used by abusers as one more means of power and control. So through VAWA, they created this path for survivors to be able to petition for themselves and cut that abuser out, so that can no longer be a means of power and control. And there's a few different types of relief under VAWA, depending on the circumstances that somebody is in. So I won't go into a whole lot of detail, but just to note that whether somebody is in the process of applying for a green card based on their relationship to the abuser or hasn't even started that process, whether they have their conditional green card based on that relationship, and also whether they're in removal or deportation proceedings in the immigration court process, VAWA relief can be available in all three of those circumstances. A fourth type of relief is special immigrant juvenile status, and this is exclusively for minors, so under the age of 21, who are unmarried and who cannot reunite with one or both of their parents due to abuse, neglect, or abandonment. There's a kind of a two-part process that first involves going to state court in Connecticut. It's usually the probate court, but sometimes can be through other venues as well. And getting an order from a judge in state court who has jurisdiction authority over the custody of the minor, and getting an order from that judge stating why, under state law, there's been abuse, neglect, or abandonment, and therefore why it's not possible for the minor to reunify with that parent. From there, you then apply to immigration for this special immigrant juvenile status, and once that is approved, the minor can go on to apply for their green card for their legal permanent residence. One caveat to note is that with SIJ, if the minor does proceed to get their legal permanent residence through SIJ, they would never be able to petition for either one of their parents. And that includes the non-abusive or non-neglectful parent. So for instance, if mom was abusive and the child is in the custody of dad, and the child goes on to get their green card through SIDGE. The child, once they become a citizen, if they decide to go forward with that, they would never be able to apply for their mother, to petition for their mother in a family case, but they also would never be able to petition for their dad, even though dad was not the abusive parent. So just an important thing to note that we always make sure to advise our clients of, because that's a significant consideration when deciding whether they want to proceed with that. And then the last form of humanitarian relief is asylum, which I'm sure folks have heard a lot about over the past couple of years in the news. And I just also note there's some other related forms of relief for torture survivors and other folks who are in the deportation process that are similar to asylum. But essentially, the big difference with asylum and these forms of relief compared with the U, the T visa, VAWA, and SIDGE is that asylum focuses on a harm that has already occurred in home country or that is feared will occur in home country. So here we're talking about a foreign harm as opposed to a harm that occurred in the United States. Specifically, the applicant needs to show that the harm that's occurred or that they fear is going to happen because of or on account of one of the 5 protected grounds that have been identified in the law. And that is their race, their religion, their nationality, their political opinion, or because they're part of a particular social group. And those are all very sticky areas of the law, which again, attorneys can help figure all of that out. But the important piece is that there has to be some connection between the harm and one of those aspects of the applicant in order to qualify for asylum. And they also would need to be able to show that their government in their home country is unable or unwilling to protect them from the persecutor. Asylum in particular is a very, very complicated area of the law, and although it is possible to apply for asylum pro se without representation, especially right now, I strongly advise that anybody who thinks they may be eligible for that at least have a consultation with an attorney, if not proceed with the application with an attorney, because it's incredibly difficult to prevail in those types of cases without legal assistance. And again, all 5 of these case types are matters that VRCCT is able to handle. Next slide. I did also want to include just a little bit of information and some resources about Know Your Rights. Because I know a lot of the times there are just some basic questions that folks have that even non-legal service providers can help give them some information about their rights that they are entitled to regardless of their immigration status. So I've listed here the basic rights that all folks in the US are entitled to, again, regardless of what their immigration status is. And then there's also a couple of fantastic resources that I would point you to. First is, apologies, I just realized the typo that should say ILRC, not IRC, so Immigration Legal Resource Center, so I apologize for that. So the ILRC is an organization that provides a lot of different assistance, both to attorneys and to immigrants directly, but they have these little plastic cards, if anybody's seen them, they're great, they're like pocket size, kind of the size of a credit card, and they have them available in different languages. And they basically have, a list of the rights that somebody has, and they're written in kind of a first person way. So, I am asserting my right to remain silent. I would like to contact my attorney. The idea being that if the person has it on them, if they have some kind of interaction with law enforcement or ICE, they can just take the card out and hand it to the officer instead of having to assert those rights verbally because, whether there's a language barrier or just the fear of that situation, understandably, it can be difficult to do that sometimes. Those cards are available free of charge to qualifying organizations, usually nonprofits and social service providers. And they're just, like I said, a fantastic resource to just kind of have on hand and be able to hand out to folks. The ACLU also has some really great guides on their website, specifically for immigration, but plenty of other scenarios as well. But they actually spell out, what to do in each of these different situations. If ICE is at your door, if you're in a car and you're stopped by the police or stopped by ICE, if somebody's asking about your immigration status, then it can walk you through exactly what you can and cannot do in that situation and what your rights are. They do have all of those pages available in Spanish. Unfortunately, they don't have them in other languages, but that's a fantastic resource that I often send my clients to when they have questions about, what do I do in this situation or what I do in that situation. So I would definitely have these bookmarked and on hand because these are great to have for folks who have questions about their rights if they are undocumented.
So moving on to the last two types of cases and areas of law that we practice in are housing and employment. Specifically in the area of housing, what we can do is utilize this state statute in order to help a victim of sexual violence or domestic violence terminate their lease. So many landlords don't actually even know about the statute, and if they are aware, they don't always abide by it. And so we're able to come in on behalf of the client and take the necessary steps that I've laid out specifically from the statute to ensure that not only the landlord's following the law, the victim is doing taking all the necessary steps per the statute in order to terminate her lease and her lease, and also to get a security deposit returned. We are limited we're limited in resources. Obviously, most nonprofits are, as you all may understand that in your own practice. But also, different areas of law are more complex than others. And so we try and utilize our resources in areas where we can find the most success for clients. And so this has been something that has proven very effective in assisting clients who are victimized, in their homes especially, and need to relocate, or if the offender lives nearby or the offender is aware of where they live, and there's fear also for that reason. So that's the kind of really the only area for housing that we assist with. We don't go into housing court and handle landlord-tenant issues. There's just a lot of complexities and nuances with that, and we just simply don't have the resources to assist in those types of cases. So we would refer out either to private counsel, pro bono service providers, or pro bono service providers if possible. Also in the area of employment, so we've successfully negotiated for accommodations with employers under the American with Disabilities Act. We can file CHRO, that's Commission on Human Rights and Opportunities, the Equal Employment Opportunity Commission for complaints of sexual assault and discrimination. And also we've helped clients obtain unemployment benefits if the cause of employment is linked to the victimization. So we just want to note, and we want to make sure that it's a takeaway every time we give this training, that all civil legal remedies could carry serious consequences for the victim, and they should be sought only after consulting with an experienced attorney. And you may have already heard both Kaylee and I use the word consequence many times throughout, because again, when you immerse yourself in the civil legal system, in the criminal justice system, even as a victim of crime, there could be serious physical, emotional, legal consequences to any decision that you make. And a lot of times clients will come to us after receiving advice from a non-lawyer, and they've taken steps in their life, taken legal action in their life to try and address some of their legal needs. And unfortunately, maybe it wasn't the right decision after we've consulted with them. A perfect example of this that we see very often is we'll have clients that come to us and we'll say, I filed a restraining order, or I filed a protective order, and with applications for restraining and protective orders, you have to have a sworn affidavit of facts alleging why you need said order. And they say, can you help us, with the hearing? And so we sit down with them to even discuss whether or not it's appropriate for them to have filed for a protective order or a restraining order. Maybe there's another form of relief that's more appropriate, or maybe now that they filed the affidavit and they have a criminal case pending, it's going to affect their ability to testify, or maybe the prosecutor decides that they're going to get the transcript or the affidavit from the proceeding and compare it to the statement in the police investigation, and maybe there's inconsistencies, and now the offender can't be arrested because the prosecutor won't sign a warrant. And these are all realities, and these are all things we've seen play out. So it's so important for victims to seek legal counsel before taking any of these steps. If it's not something that we can necessarily help with or consult on, maybe someone within our network we can make a referral to in order to get the victim the support and the consultation and the legal assessment that they need before making that decision. And a lot of times the victims who have made those decisions have made them based on information coming from non-lawyers. And so for all of the reasons that we've already discussed, but again, just to really hammer home the point that it's so important whenever you're working with clients who have legal needs to connect them with an attorney as often and as early as possible in their process.
And one note related to that is part of what we see as being trauma informed is being client centered. And so after we meet with the client and walk through all of the options with them and the pros and cons and the consequences and, you know, the different scenarios that could play out depending on which action they decide to take, at the end of the day, it's the client's decision. And there are some clients that we serve for whom the best decision for them in that moment is not to do anything at all. And that is completely okay, and we respect that wholeheartedly. Our focus is never on telling somebody what is best for them or what they need to do, but rather to be a resource to give them the information and the access to different systems that they may choose to engage with. But then leaving it up to them to make the decision, because at the end of the day, you know, they're the experts in their own lives and what they need in that moment.
That's an excellent point. Thank you for adding that. So I've already given a variety of case examples of clients needing to, again, break a lease for the variety of reasons that I mentioned. Also for employment, we've had cases where a victim was experiencing, you know, severe PTSD symptoms that was really affecting them at work. And so we were able to work with the employer to get reasonable accommodations for the client. We've done that in the school context as well for students, as I mentioned earlier. Kaylee, I don't know if you wanted to specifically mention any further examples about immigration. I also, just noting the time, we're a little towards the end of our slot, so maybe we want to move on.
Yeah, I think that we've given a sense of what we do, and again, just that we try to be holistic as much as possible and cross off as many of those needs as we can at the same time.
And if there are things that we get new things that come to us all the time as well. So it's something that maybe we haven't done before, and so it wasn't in a slide, or I didn't give the example for, but we've had clients come to us with, you know, an employment concern, and it's not something, it's something new and different. We're always willing to explore those legal remedies as well, and sort of work together as a team to again, provide holistic services as much as we can, rather than have the victim have, you know, 4 different attorneys for 4 different legal needs. So we often get asked to how we get our cases. We have no shortage of referrals. I think I created this slide many years ago, and maybe it's not as necessary anymore to include because our referral base has grown and expanded so vastly throughout our state. But certainly we like to note that our work would not be possible without the collaboration and support from our state and national allies and partners. And we've listed some of our state-based, we've listed some of our broad-based. We'd certainly love to include you all, you know, if when appropriate. We often also get asked, how can providers make referrals to VRCCT? And so in the next, if you want to move to the next 2 slides, we actually included our referral form. And so that can be sent to, I can send that a blank form, which is password protected, to Amber. And if Amber wants to distribute it to the attendees and any of the other providers that she sees fit, and then we're happy to accept those referrals directly from the service provider or from clients can self-refer. We never want this form or lack of this form to be a barrier to services and referrals. So if a client just wants to call themselves, that's the office number. If a service provider wants to call and provide a referral, that's fine too. That's the phone number to do it as well. Of course, the more information we have right from the beginning, I think the better we can, ultimately move to serve the victim. But certainly, we never want a lack of access to email or fax or that form to be a barrier. So we'll take referrals however is best and most efficient for the client or for the service provider. Now we will open it up for questions. Amber, I don't know if there are any sent or if any have come up.
We have a few questions, but before I get to that, we have many comments where people are just thanking you for your service, and not just for the legal representation, but also having a trauma-informed lens and really working with our population on what is best for them and empowering them, to make the best decision for them. So thank you for that before we go into questions. Also, we have a few questions around discrimination. You mentioned it in your beginning slide. I know you touched on a few, but for discrimination, can you speak a little bit about that as far as how you will work with someone that experiences discrimination because they're from the LGBTQ population or race, and they were some type of a victim of a crime with that as well?
Absolutely. So, I mean, I think it depends on what context the discrimination is occurring in. So if it's in an education or in an employment context, that's going to vary. The remedies are going to vary depending on what context you're in. But certainly if we have Title IX remedies, if it's in an educational context, and then if it's in an employment context, that's when we would take the case and we could file a complaint with CHRO or EEOC, CHRO on the state side, EEOC on the federal side. And so those are the typical remedies that at VRCCT we provide. Keely, I don't know if you can think of any others as far as that question.
No, just on the immigration side, although there's in terms of the list of qualifying crimes for a U visa, so if the individual is undocumented, there is not anything exclusively tied to LGBTQIA. However, if there was, for example, a felonious assault, and that was based in part on the individual's gender identity or sexual orientation, that could possibly qualify them for a U visa because an assault is a particularly serious crime. In addition, I would mention that although the Violence Against Women Act specifically, and its name says women, the relief that I mentioned is not limited just to women, nor is it limited to heteronormative relationships. So folks who are part of the LGBTQIA community would still be eligible for those forms of relief under VAWA, as long as they would be able to meet the other requirements. And for anybody who has experienced any harm outside of the United States, based on being part of the LGBTQIA community, those types of cases are regularly, pretty straightforward in terms of being part of what we call a particular social group. So if the harm was outside of the US, that membership could also be a basis for protection for asylum or other related forms of relief.
Thank you. And I know you all do work with adults, but do you also provide services for children that may have experienced some neglect or emotional abuse, especially when it comes into child custody issues?
Absolutely, yes. So we represent both minors and adults. One of our grant funding streams does not allow us to represent children under the age of 11. However, our other funding streams allow us to represent children of all ages. So yes, we absolutely serve that population.
Right, and I'm just reading some questions. If you all have any additional questions, please feel free to input them and we'll try to get to them. I know we are running short on time. I have received a few questions where people are asking, will this be available? Yes, it will be available on our webinar library, and I can also email it out in PDF form to all of you all that have attended the slides as well as the recording if you would like to share with your coworkers. Okay. And if you can just speak a little bit about your experience with working with individuals that have experienced this sex trafficking.
Go ahead.
Sorry, we both did the inhale at the same time. So we are actually, both Maura and I sit on the Connecticut Bar Association's Human Trafficking Committee, and we are heading up the subcommittee for pro bono representation. So we are in the process on behalf of that group of putting together a statewide network of pro bono attorneys, both from nonprofits and private firms, who can provide pro bono representation to trafficking survivors, both labor and sex, and also foreign-born and domestic, in a variety of different areas. So anything from immigration to family law to education law to criminal law needs. We have a whole list that we've curated with the input of providers who work exclusively with trafficking survivors, really pinpointing what they most need. So we are in the process of putting that together, and once that's up and running, we're hoping that that'll be a really good resource for folks who encounter survivors of human trafficking. Additionally, VRCCT is able to serve trafficking survivors in any of the practice areas that we've gone over today, including immigration. I don't know that we have had that many cases. I think that's in part because there are some organizations that have been identified, and I think just have existing partnerships that they've been receiving a bulk of the trafficking cases that do exist, but we're absolutely available to take those and would be capable of handling those, again, because we do practice a trauma-informed lawyering approach, and I think that that would be particularly appropriate for trafficking survivors.
Great, thank you so much. And I see we are at the end of our hour. Actually, we went over a bit, and that's the last bit of questions that we had come in. So Maura and Kylie, thank you so much for your presentation today, offering these services, just giving a full overview. Service providers is always really, really difficult to navigate these types of situations, and knowing that you all do it and you come from a place with so much passion, but you also do it for free. That is great. We're nonprofit as well. Just to be able to provide as much assistance and support and empower our participants as much as possible. So I really thought it was important for you all to join us today. So thank you so much. The webinar will be available, the slides will be available, and I truly encourage you all to reach out to them. I'm sure you all can think of many clients that you have that will fit these different categories and can benefit from their services. So thank you all so much. If there's anything additional, you have Kylie and Maura's information on the screen in front of you, but if there's anything additional that you have any questions or ask of me, you can also contact me at training@cceh.org, and I will be happy to assist. So thank you all so much, and have a great day.
Thank you.
Thank you.